To protest today outside the U.S. Supreme Court as justices hear arguments testing the legality of a ban on gender-affirming health care for minors. The case originates from Tennessee, but it could affect laws in both the Carolinas. Joining me now to talk about it, Chief Legal Analyst Khalif Rhodes. And Khalif, this is a deeply complicated but also a highly polarized political issue here, as the interesting responses here that elicited from the justices.
Well, let's start here. You're talking about deeply complicated. I got to put the perspective for you and for folks at home. This is like the Gladiator meets the Super Bowl. Like, you are at the pinnacle of your profession if you get an opportunity to argue in front of the Supreme Court. But then you have these 9 folks that are looking down at you with a gallery behind you, and you got to answer all these questions, 100% being on your toes if they're trying to throw you off. But most of the questions I could say that centered on from the conservative justices, Alito, Thomas, Kagan, she had a couple comments as well, but I for sure think most of their comments, specifically the conservative justices, were centered around, should we even be here? Is this something that we should even touch? Roberts hit on it, Kavanaugh hit on it. These are folks that want to know, is this a question for this court? Is this case even ripe to be here? Which is, I think, a deeper question. But I think if you are at home and you're saying, I want to go to law school, if you're saying, I want to make sure I want to become an attorney, you need to listen to these type of arguments. The last couple of years, the cases that have come before this court have been rock star type of cases to hear, because the folks that are presenting the cases before the court, they are, I mean, the best of the best. The arguments today basically goes right down the middle. Has the state of Tennessee created a law that is drawn a bright line test? Did it create a law that says you get a different treatment if you're a male than if you're a female? And you just have to look at the law. Under Tennessee law, an adolescent assigned female at birth cannot receive puberty blockers or testosterone lift at present as a male. But an adolescent assigned male at birth can. That's the argument. It boils down to that. And there was a lot of back and forth. There was a lot of tennis. There was sometimes tug of war. But ultimately, the Solicitor General tried to take the argument back to the courts to say, listen, if the bright line standard test is there, and it seems like it's on this case, why are you not sending it back to the court to make them do the right standard of review?
There's, in the past couple of years, there's been a couple dozen states that have enacted a law like this, including here in North and South Carolina, where they ban those therapies that you're talking about.
You're talking about 26 plus states, but every state is not doing it the same. North Carolina doesn't have this language. A state that I can look at is West Virginia. It was mentioned in the hearing. They don't have the same standard. And the Solicitor General gave an example. She said the reason that West Virginia doesn't use this same standard is because their top person in the House there was a former doctor. And so he understood the benefits and the negative implications that could come from implementing a law such as this. So back and forth today, there was a lot of talk about medication. There was a lot of talk about structure. But ultimately, she tried to guide the argument back to, what is the standard? And I can quickly tell you what the standard. There are 3 standards when a court looks at a constitutionality of a law: intermittent scrutiny, rational basis, and strict scrutiny. She's arguing that it should be intermittent scrutiny, that you should be able to have to prove that there is a rational basis that is higher than that. It's something that's required for you guys to make an assessment and ensure that the state has to be able to point to a reason why this law should be in place.
When would this come out then, as far as the decision for the justices to make this?
It'll probably be sometime later next year, probably in the middle of the year. You normally give them that 4 to 6 month time frame. For sure, June or July. I mean, but here's the other thing. By the time we get there, there'll be a new administration. There'll be a new Solicitor General. They probably won't even want to push forward on this case, but the hearing's already been had, and this case will already have been heard at that moment.
All right.